May 2nd, 2022.
And I was actually standing on Main Street in Disney World, staring at Mickey's Castle, waiting for the fireworks to occur. I was with a colleague of mine, and his phone started blowing up, and my phone started blowing up, and I just remember kind of like kneeling down with my head in my hands because we knew and we had made these very concrete plans that this was going to happen.
Politico publishes a leaked draft of a Supreme Court majority opinion written by Justice Samuel Alito. Choices Center for Reproductive Health president and CEO Jennifer Pepper has been in her role for a little more than a year.
It was like the last little bit of hope leaving my body that maybe we were wrong, that we were going to be wrong, because we wanted to be wrong.
That ruling, officially releasing in June 2022, fundamentally changed the healthcare landscape of the United States. The Dobbs v. Jackson Women's Health case overturned Roe v. Wade, and with it, nearly 50 years of federal abortion law.
My colleague, who was actually my chair of my board, said, let's just put our phones away. This is going to be there when these fireworks are over, but let's just pretend this isn't happening for 20 more minutes. And so that's what we did.
Multiple states had trigger laws set in place to immediately ban abortion with extremely limited exceptions if Roe was overturned. Here's Andrea Gallegos, executive administrator at Alamo Women's Clinic. She was working in Texas when the ruling came down.
Every day leading up to it that we saw patients was a victory because we had gotten through the day. We had been able to see that many patients for the day. And so then having to face the patients in the waiting room and explain that, yes, we have the ability to see you today, but, the Supreme Court has told us we can't.
The fallout from that ruling would drive Gallegos to move to an unfamiliar state to provide care.
There were shrieks, there were cries, there were screams. Patients begged and pleaded to see them anyway. They were there. What are they going to do? So we had to, talk to each patient about their options and send them away.
Kentucky, Tennessee, and Missouri each had trigger laws, which immediately went into effect. Indiana banned abortion in September of that year. Other states limited access with 6, 12, and 18-week bans. This week on the Crossroads Suncast, how that decision brought a small college town in southern Illinois to the forefront of the battle over abortion rights. And, 3 years later, the state of the abortion landscape and the ongoing fight. I'm Bryce Patterson. As of the 2024 census, Carbondale, Illinois had a total population of slightly less than 22,000 people. But the city is home to 3 clinics providing abortion services: Planned Parenthood, Choices, and Alamo Women's Clinic. According to the Guttmacher Institute, 1 in 7 people seeking abortion care crossed state lines to do so last year. A quarter of those patients went to Illinois. A third of Planned Parenthood's out-of-state abortion patients sought care in Carbondale. That's a major shift in the wake of the Dobbs decision, but it didn't come out of nowhere. Gallegos says, that summer, location became everything.
The Dobbs decision made, geography a privilege to healthcare. If you so happen to live in a state where you can access care, it's now a privilege. And if you don't, it's a burden.
Imagine a map of the South and Midwest. Illinois is bordered by Wisconsin, Iowa, Missouri, Indiana, and Kentucky. Each of those states has implemented significant abortion restrictions in the wake of the Dobbs decision. East of the Mississippi, Carbondale is the farthest southern point for millions of patients seeking abortion care. Missouri voters chose to enshrine abortion rights in the state constitution in November 2024. We'll get to the current restrictions in that state later on in this episode. Kentucky's laws are fairly typical of other states in the region. Currently, abortion is banned in Kentucky with limited exceptions, and the state has an interlocking collection of laws designed to restrict abortion access. Patients seeking abortion care are required to take 2 trips. The first provides in-person counseling. Patients have to return at least 24 hours later for the abortion medication or procedure. In Kentucky, both state Medicaid coverage and private health insurance coverage of abortion is banned except in very limited circumstances. Medication abortion can only be provided after an in-person visit because the state bans the use of telehealth for abortion care. Parental consent is required for anyone younger than 18 getting an abortion, and only physicians can provide abortion care. Move farther south, and similar laws are in place in Tennessee and Arkansas, and stretching all the way south to Mississippi, Alabama, and Louisiana. In the wake of the Dobbs decision, that range of interlocking restrictions made it hard for patients to know whether they had access to care. Here's Julie Ewell with Planned Parenthood of Illinois.
Immediately that same week, there was so much just chaos and confusion being experienced by patients not knowing what their options were anymore. Our contact center experienced a huge spike in call volume from patients just not knowing if abortion was legal anywhere anymore.
Let's zoom in on Illinois. In the 2024 election, Jackson County, where Carbondale serves as the county seat, went for Kamala Harris with a little less than 51% of the vote. Every neighboring county in Illinois voted overwhelmingly for Donald Trump. It's a blue speck in a sea of red. Carbondale also sits on a passenger rail line, running from Chicago south to New Orleans. That location means abortion providers in Carbondale serve a massive swath of the South and Midwest.
Since Carbondale opened, it was December 2023, 90% of the abortion patients seen there have been from a state other than Illinois.
Ewell says changes to the law don't actually impact the demand for abortion care. They just change the location for people seeking support.
In that first year, we saw an almost 50% overall increase in abortion volume across our whole network of health centers across the state.
The shifting legal landscape makes access to abortion care a costly struggle. Here's Jennifer Pepper.
Lots of folks don't have paid time off. Childcare costs are rising and an issue. Most people that seek abortion care are already parents, so they already have children. Maybe now they're losing wages. They're having to drive 7 hours instead of 3 hours, so now it's an overnight trip instead of a day trip.
Planned Parenthood already had programs in place to ensure access for patients coming from other states. It's part of a broader initiative focusing on the barriers to care that come with travel. Julie Ewell says that program has its roots in past struggles for abortion access.
So the patient navigation program was actually started as a nationwide pilot by the National Planned Parenthood Federation back in, I want to say 2021. So it was prior to the Dobbs decision. And it stemmed out of seeing the impact of COVID on abortion access. Because I don't know if you recall, there were some states that classified abortion care as non-essential healthcare effectively, so use this COVID pandemic as an excuse to shut down abortion clinics.
Those patient navigators routinely work with people who have never been on an airplane before or don't even have a driver's license. With its location in deep red southern Illinois, Carbondale's new role in the abortion landscape didn't come without controversy.
We would have contractors agree to come and do the work and then back out when they found out what we did.
Along with locals raising concerns, Choices, Alamo Women's Clinic, and Planned Parenthood also face pressure from national anti-abortion groups like Missouri-based Coalition Life. The fight there would make it all the way back to the Supreme Court. In 2023, Carbondale's City Council enacted a buffer zone ordinance in response to concerns about disruptive behavior outside of clinics. According to Capital News, Illinois, in the first 2.5 years after the Dobbs decision, Carbondale police responded to more than 250 calls regarding disturbances at clinics in the city. The ordinance made it illegal to come within 8 feet of a person without their consent, within 100 feet of any healthcare facility. Legal precedent for the buffer zone ordinance goes back to the Supreme Court's ruling in Hill v. Colorado 25 years ago, which upheld a similar law in that state. Coalition Life sued to overturn Carbondale's buffer zone ordinance in May 2023. That suit, arguing that the law has a chilling impact on freedom of speech when it's most important. Coalition Life engages women outside of facilities offering abortion care, seeking to divert those patients to health services and other resources from clinics that do not provide abortions. In July 2024, the city of Carbondale rescinded the buffer zone ordinance during a rare Saturday meeting. 3 days later, Coalition Life petitioned the Supreme Court to review the Carbondale case anyway, hoping to overturn the precedent set by Hill v. Colorado. I talked to Peter Breen, head of litigation for the Thomas More Society, when that suit was filed. As a lawyer representing Coalition Life, he said abortion care gets special protections that are unconstitutional.
We know full well that if somebody had tried to put an anti-speech zone around any other sort of facility, a business of any type, except for an abortion facility, the courts would have struck it down.
Even though the ordinance had already been repealed, Coalition Life argued the buffer zone's impact on freedom of speech was ongoing. The case sat on the Supreme Court's docket for months, but didn't get the votes necessary for a review. A dissenting opinion from Justice Clarence Thomas highlighted the changes in the wake of the Dobbs decision, saying that the legal reasoning upholding buffer zones no longer held in the post-Roe V Wade era. His dissent reads in part, quote, "Following our repudiation in Dobbs, I do not see what is left of Hill. Yet, lower courts continue to feel bound by it. The court today declines an invitation to set the record straight on Hill's defunct status. I respectfully dissent. Hill has been seriously undermined, if not completely eroded, and our refusal to provide clarity is an abdication of our judicial duty. I would have taken this opportunity to explicitly overrule Hill. For now, we leave lower courts to sort out what, if anything, is left of Hill's reasoning, all while constitutional rights hang in the balance." In November 2024, voters in Missouri passed Amendment 3, a ballot measure enshrining reproductive rights in the state's constitution, and effectively ending one of the strictest abortion bans in the nation. A judge put the state's many abortion restrictions on hold, and Planned Parenthood started providing abortion care again. Just 6 months after the election, in late May, Planned Parenthood paused all abortion care in Missouri. The change? A ruling from the Missouri Supreme Court. The actual legal shift is pretty complicated, but here's the basic outline. Amendment 3 adds to the state constitution the right to, quote, "make and carry out decisions about all matters relating to reproductive health care, including, but not limited to, prenatal care, childbirth, postpartum care, birth control, abortion care, miscarriage care, and respectful birthing conditions." The amendment passed with a narrow 52% of the vote. Planned Parenthood and the American Civil Liberties Union sued in the immediate wake of the 2024 election to repeal the state's abortion ban based on the language in Amendment 3. The court put on hold many of Missouri's abortion restrictions, but abortion care didn't restart immediately. The issue? Missouri's network of laws that discouraged abortion access without outright banning it.
Even prior to the Dobbs decision, when Missouri wasn't technically under a ban, it was effectively still banned because of how many restrictions were in place.
That's Nick Dunn with Planned Parenthood Great Rivers Action. Dunn is one of the activists who fought for the passage of Amendment 3 in the lead up to the election. Trap laws, or targeted restrictions on abortion providers, are a range of state and local regulations on abortion clinics that were already in place in Missouri prior to Dobbs. Missouri State Judge Jerry Zhang put on hold many of the state's trap laws and rulings in late 2024 and early 2025. The state's Attorney General, Andrew Bailey, challenged those decisions. The Missouri Supreme Court adopted a more rigorous legal standard for blocking statutes in May, and directed Judge Zhang to issue a new order based on that framework. It's a technical difference, but it allows Missouri's many trap laws to go back into effect until Zhang issues an updated ruling. Missouri's Attorney General says the passage of Amendment 3 left abortion facilities, quote, "functionally unregulated," giving their patients, quote, "no guarantee of health and safety." The laws going back into effect impose a range of standards not applied to similar healthcare facilities. That includes requiring anyone performing abortions to have admitting privileges at a hospital within 30 miles or 15 minutes of where an abortion is provided. Proponents say those rules are designed to protect women seeking care. Writer and lawyer Bridget Dunlap says those rules work to shut down access to abortion.
So you require that the provider have admitting privileges at a hospital within a certain radius. And which sounds like fine. Yeah, why wouldn't you want admitting privileges? But there are a lot of reasons a hospital isn't going to give an abortion provider admitting privileges. Politically, it's a problem for the hospitals to give an abortion provider admitting privileges. That it brings them political heat, and it's not going to bring them patients.
She says the rules hold abortion providers to different legal standards than other clinics providing similar care.
it's really easy to tell when it's discriminatory against abortion care because it entails the same procedures and medications as miscarriage care. So if you've got a regulation that applies to abortion but doesn't apply to miscarriage care, you've got discrimination there.
Dunn says the Missouri Supreme Court ruling is a temporary setback, and he's hopeful the courts will rule in Planned Parenthood's favor. He says restrictions like the ones in place in Missouri have impacts beyond just abortion care.
Abortion bans drive OBGYNs out of the state. What we have seen in Missouri is a drastic drop in OBGYN residency applications at Missouri universities because they cannot practice the full spectrum of care in the state. People across the state have even less access to just your general gynecological care. Like that's a challenge already in Missouri, where we have high maternal mortality rates, where we have high STI rates, and those are things that we're trying to improve. But that cannot be done without access to care within our own communities.
Infant mortality rates rose nationally in the wake of the Dobbs decision. Some abortion restrictions are also linked to higher maternal mortality rates. In May, lawmakers in the Missouri legislature passed a resolution calling for another referendum on abortion. That's set to appear on the November 2026 ballot, unless the state's governor calls a special election sooner. If passed, the initiative would once again ban nearly all abortions in the state. We reached out to Missouri Representatives Donnie Brown and Barry Hovis about the reasoning behind that resolution. We haven't heard back as of this episode being published. Access to abortion care continues to shift. As I finalized the script for this episode, the Supreme Court ruled in favor of South Carolina's move to strip Medicaid funding from Planned Parenthood. It follows the Trump administration freezing tens of millions of dollars in funding for family planning clinics in March. At least 20 Planned Parenthood clinics have closed or announced plans to close over the course of this year. Planned Parenthood has also warned about the impact of potential cuts to Medicaid. In a May press release, Planned Parenthood of Illinois President and CEO Tanya Tucker writes, quote, "Over 40% of PPIL patients use Medicaid to cover essential health care, like birth control, cancer screenings, STI testing and treatment, gender-affirming care, and abortion services. Without Medicaid, PPIL would be forced to make drastic cuts, including possibly closing health centers and increasing the costs for our patients." The impact isn't just felt by Planned Parenthood. Reporting from the Kentucky Lantern finds that nearly 60% of abortions in the U.S. are provided by independent clinics, like Choices in Alamo. According to the Abortion Care Network, almost a third of independent abortion clinics have closed in the last 6 years. Senate Minority Leader Chuck Schumer says the GOP's big beautiful bill is a, quote, backdoor abortion ban.
They have their way. Nearly 200 Planned Parenthood health centers in 24 states would be at the risk of closing. More than 90% of these closures would be in states where abortion is currently legal. So it'll affect, you say, well, I'm in a state that has protected women's rights. You're not safe.
President Donald Trump has said he wants that bill on his desk by the 4th of July, next Friday. On Tuesday, the 3-year anniversary of the Dobbs decision, Illinois Senators Tammy Duckworth and Dick Durbin joined the entire Senate Democratic caucus to co-sponsor the Women's Health Protection Act of 2025. If passed, the bill would create federal rights to abortion access for both patients and providers. It would prohibit states from imposing restrictions on abortion access early in pregnancy. And it would prohibit limitations in the later stages of pregnancy if those restrictions would risk the life or health of the mother. The bill also protects out-of-state travel for abortion care. If there's a story you'd like us to cover on the Crossroads Suncast, reach out. The best way? Email us at newstip@wpsd-local6.com.